Sandra Stead.
Yes.
Okay. All right, we're on the record in People versus Sandra Stead, file number 255495. The record should reflect Ms. Stead appearing today by video from Wisconsin jail. If I could have counsel for your appearance done.
Here, talking on behalf of the people.
Thank you, Honor. Jason Thompson, Sandra Stead.
All right, this is set for a status conference today. Mr. Thompson, can you tell me the status of this file?
Yes, Your Honor. There is a plea offer in this matter. If Ms. Stead pled guilty to count 1, possession of methamphetamine, the prosecutor agreed to dismiss counts 2, 3, 4, as well as the potential enhancement. So it would be a 10-year maximum for possession of methamphetamine.
So is that a correct statement?
It is, and we did agree to dismiss the drug double. I know she has a pending case in Roscommon. I think we had adjourned it so she could work on that case. It's not going to change the offer, but that is our offer.
Yeah, it's my understanding she's pleading in Roscommon, so we just asked to get the sentencing as close to their sentencing as we could.
Okay. All right. Ms. Stead, were you able to hear what the lawyer said about the plea agreement?
Yes.
Have you had an adequate opportunity to speak with your lawyer about that agreement?
Yes.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can lower your hand. Ms. Stead, are you currently on any kind of probation or parole?
No.
You understand that the maximum possible penalty you could face for this charge, which is possession of methamphetamine, is up to 10 years and or a $15,000 fine?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said on the record?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates that this happened back on April 30th of 2025. Is that the correct day?
No.
Okay, what was the date to your recollection?
May 22nd.
Okay. On May 22nd, were you present here in Crawford County?
No, actually, I was here in the Roscommon County Jail.
All right, well, the charge in this case alleges, again, I'm using April 30th. It alleges that on April 30th, you were here in Crawford County and you had possession of some methamphetamine.
No, I didn't. It was all the same day as the day I came in here, and then they searched my room the day they arrested me and put me in here, and then they went and searched my room that next day. And that was in May.
Okay. Was your
That was
room
May
located,
21st. I came in here and
what, on that day in May, was your?
my room is located in Crawford County, yes, but on that day, no, I did not have methamphetamine on my possession. It wasn't until May.
Okay, all right. That's fine. So in May, the police did a search of your room here in Crawford County.
Yes,
And during that search, they found methamphetamine.
yes,
Was that your methamphetamine?
yes,
Okay. Did you have any legal right to have that methamphetamine?
no,
Ms. Koch, are the people satisfied with the factual basis?
Yes,
Mr. Thompson?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
no, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute, court rule, and the taking of this plea?
Yes,
Yes.
Thank you. Ms. Stead, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied based on your statements that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Between now and then, you'll be, someone from the probation department will be in touch with you for a pre-sentence report. Mr. Thompson, based on the arrest common matters, should we set that for when do we need to set this for?
Ms. Stead, do you know your date for your common sentencing?
as of right now, it is January 13th. There is a possibility it be pushed out till February, but yes, as of right now, it's January 13th.
So I guess we should try to get close to that date.
All right. Okay, so we can set it for January 8th. And Ms. Stead, did you have the right to have your sentencing hearing on this Crawford County charge here in Crawford County? And if you wanted to exercise that right, I would sign an order to have you transported here for the purposes of that hearing. You can waive that right and we can do it by video like we're doing today. Do you know how you'd like to proceed?
Yeah, that's fine. I'm okay with that.
By video?
Yeah,
Okay, so we'll set this as a sentencing by Zoom from Roscommon County. That's all for the hearing today. Ms. Stead, do you have any questions at all?
no, I don't think so.
Okay, thank you. We're gonna disconnect at this time.
Thank you.
Lit. This is file number 255480. The record reflects Mr. Witt is present here in the courtroom today. This is the date and time set for sentencing. Mr. Witt, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections?
No, Your Honor. Thank
Are there any challenges to the hearing?
you. No.
Oh, do you have any additions, deletions, or corrections?
no, Your Honor.
Any challenges to this point?
No, Your Honor.
Anything on behalf of the people for allocution today?
You know, this is one of those anomalies where you see somebody who's 36 years old with no criminal history, no juvenile history, no misdemeanors, really no interaction with law enforcement at all throughout his life, and then makes a bad situation of, drinking and driving at a .214 into something much worse by his own behavior. I hope that he takes this seriously. I think the recommendation is appropriate, and I hope that we don't see him again. Thank you.
Mr. Thompson?
I agree, Your Honor. I was working tell that evening he behaved badly, and he's very ashamed that he regrets it very much. I think the court does have to put it in the proper context, which is 36 years old, good job, sterling track record, no problems with law enforcement, no issues. He got drunk that day and made him the idiots. And it was idiotic to be driving at a .214, and then it was idiotic to be not immediately complying with the police, and that's on him. That's the mistake he made. I do want to just put in context for the court. He had a surgery just a couple weeks earlier. He's got a problem with his bone on his hand. He's got him off work, caused that surgery. When he was being an idiot and he was not immediately complying with police officers and they started to restrain him, they caused him a lot of pain by the way they were restraining him because he had just recently had a surgery on his hand. And I think that's part of why after that he did, you know, kind of react physically. But he put himself in that circumstance, Your Honor. So I don't want you to think I'm trying to blame police officers or anything like that. I am trying to explain part of what happened that day was he did experience a lot of pain in his hand where the officers wouldn't have known that that would have been such a sensitive spot for him. Having said that, Your Honor, having said that he acted inappropriately that day, I hope none of us get judged solely on the worst day of our life. And for a 36-year-old guy, you know, I think this can end up being more of a wake-up call for him. I think this can end up being the worst day of his life and something he improves from. I did want to sort of follow up in the substance use and treatment part of this report. It states that he told the probation officer he didn't think he had a drinking problem. I've talked to him some more. I don't think that's what he would say today, and I don't think that's accurate. And what I tell a lot of my clients is, you know, you can debate about the semantics, but you have a problem, and it's from when you were drinking. So you have a drinking problem as far as I'm concerned. I mean, he's got a huge problem. He's before a circuit court judge today. He's got a huge problem in his life now, and it was caused by his drinking. So he understands that's a drinking problem. That's a problem in his life from drinking and drinking. You know, objectively too much, 3 to 4 times a week is too much to drink. Being at a 0.214 while you're driving is objectively drinking way too much. So he now has, it's now right in front of him. And he sees that and he's taking that seriously. And he is going to AA and he's given me this AA sheet, Your Honor, as he's trying to come to grips with and learn about what's happened to his life and what could happen if he doesn't arrest and change this. So you got to put on bond conditions to not drink alcohol. He's not drinking alcohol. He's learning a lot. I don't think he's all the way through recovery. Certainly the court talks to people who've been to rehab 6 times and they, you know all the language real well. He doesn't know all the language real well, but he knows he has a problem and he knows he needs to face consequences today and own up to it. And he knows he needs to use this as a learning opportunity to not have this happen again, not put himself in such a terrible position because he acted so stupidly. And he does want to apologize to the court. He regrets what happened. Again, this is a guy with a good job, with really good family support. I think he'd be an excellent candidate for probation to do well. And this might be a situation where the court can hold his jail time in abeyance because he's going to let us know how this is going to do. He's going to be under a microscope. He's going to have to be sober. He's going to have probation officers and people watching him. And if he can turn this thing around, Your Honor, I think that we can chalk this up as, you know, thank God nobody was hurt. Thank God it wasn't worse. And maybe he learns from it. And if he doesn't, then, you know, the court's got all kinds of sanctions they can impose on him. So ask the court to consider jail time in abeyance, consider probation on this matter. Thank you.
All right, thank you. Mr. Witt, anything that you wanted to say?
Yes, I just want to start off by apologizing to the city of Grayling, everybody, the officers, you guys here, putting everybody in the state on the way up in jeopardy because I was drinking and driving on the way. And I drank a lot before I got in the car, before I came up here. And, you know, I drank on the way up. I shouldn't have been doing shots on the way up. It's just a terrible idea. I mean, you know, it's just one thing led to another. I don't think my attitude was very good. You know, going to AA, I've kind of learned a lot more about me and drinking and everything else, you know, being away from alcohol. You know, I definitely learned that I've calmed down quite a bit. You know, I've been so wound up. I haven't been working because my hand's been injured. And, you know, I just, you know, it's kind of, that drinking thing's been getting out of control. I chose to make a poor decision. I made more bad decisions with everything. You know, I just wanted to say, or I just want to apologize to everybody. You know, I made a mistake. I own up to it. And, you know, I'm sorry.
Read through the report, so I'm familiar with you, your background, your circumstances generally, as well as the details of what happened during this incident. Yeah, I think Mr. Thompson summed it up really well, and we've indicated it as well that, you know, it's probably something that's been coming maybe for a while. And this all came to a head on this particular day. Certainly the court has concerns about public safety. You indicated yourself, you really did put everybody in danger, including yourself, by driving in the condition you were in. That's an incredibly high blood alcohol level operating what is basically a bullet going 55 or 60 miles an hour, and it's just by sheer luck. And I'm glad to hear that you are getting some treatment, that you're taking this seriously. You're going to AA, and it sounds like you're discovering maybe some things that maybe this has been a problem for a while. You just didn't see it as that. This has made it more apparent. So getting help with that is going to be really important for you going forward to avoid having more trouble, to move on from this instead of this being like the first time with many. That's not what you want. Certainly not what we want as a community.
No, I definitely would like to be my last time.
Yeah,
And I'm gonna make it my last time.
getting involved in AA, getting some therapy, some help. It's the kind of things that are going to prevent it from happening again. They're not fun to do. It's not a pleasant thing, but you're going to have a better way to do that. In terms of the resolution of this, based on your employment, your individual circumstances, I don't think that probation is a good option here. Regardless of the probation, I do think that a short jail sentence is appropriate as a punishment, as a deterrent, so that you understand that this is just not acceptable behavior and there's a consequence to that. The guidelines here are 0 to 9 months, so the court could sentence you to up to 9 months in jail. I don't think that's appropriate, given the factors that Mr. Thompson outlined, your lack of prior history, and so forth. And that's why I think the recommendation here is well crafted. It provides a degree of punishment for you, and again, hopefully deterrence, so that a stay in jail is going to really drive home the point that this is not the direction that you want to go in your life. So the court is going to sentence you to the Crawford County Jail for a period of 30 days. You have credit for 2 days served. It's going to order restitution in the amount of $240.98. That's payable to the Crawford County Clerk to be dispersed to the Crawford County Sheriff's Department. Crime victims assessment of $130, court costs of $325, attorney fees of $350, OUIL testing reimbursement of $150, DNA testing fees $60, and $118 state costs. That as to both counts 1 and 2 to be served to each other. Mr. Thompson, was there something else that you address?
I was just checking to make sure we had 2 days credit.
Yes, 2 days credit. You do have the ability to seek an appeal of the sentence, Mr. Witt, Mr. Thompson, if you can, Mr. Witt, now.
Thank you. So Mr. Witt, if you initially here, that's not filing an appeal, but it's saying you received these papers, you're going to keep 2 copies. If you wanted to file an appeal, you would use these 2 copies, you would fill them out. You have 14 days to do that. You can take those with you. You're going to end up going with Steve here, okay?
Am I going to jail right now?
Yes.
Is there any chance I may be able to change?
We're going to have to go with the officer to help you take care of it.